Hey everybody, and welcome to our agricultural law edition of the CULT Brief podcast. I'm Christine Titgern. I'm the director here at the Center for Agricultural Law and Taxation. And today we're going to give you a little bit of update on some things that have been happening around the country in the world of agricultural law.
Welcome to episode 3, everyone. My name is Kit Tovar, and I'm the staff attorney here at CULT.
So Kit, it's been sort of a busy week as always with lots of things going on. And so one of the things that we're watching is that it was announced, Secretary Perdue announced that they are working on assembling a new package of assistance for farmers impacted by the China trade standoff that we're having right now. They have announced that the package will likely be $15 to $20 billion. We just don't know exactly what that's going to look like. So at the end of the year and the beginning of this year, the end of last year and the beginning of this year, you know, farmers got a number of market facilitation program payments. Soybean farmers got a big chunk of the money, and we have heard that it looks like this new package will likely target soybean and hog farmers as well. So we're watching for the details of that. As soon as it is officially announced, we'll get word out to everybody on the website. But they have said that they want those program payments to be available fairly soon. Now, we don't know if it's going to be exactly like it was last time, where it's going to be actually based on production. One of the concerns that some economists have brought up is if you announce payments and it's still planting season, will that actually alter farmers' behavior? Are they going to plant more soybeans wanting aid? So, you know, we're gonna watch and see if they make any changes based upon that concern. But that's something we're watching. Another thing that's important to the Midwest and to Iowa in particular is a disaster relief bill, getting that passed to get some aid to farmers who have been impacted by different disasters that have happened throughout the country. So it's important to everyone, but a number of our farmers here in the Midwest, Nebraska, Iowa, even recently the Davenport area got flooded. There's just a lot of natural disasters that have happened. So Senator Grassley and some other senators have put forward a disaster relief bill, but it has not gotten anywhere yet. And so there is discussion right now. A special assembly of legislators was put together to look at what would need to happen to get that through. And interestingly, they decided to sort of put it together with the tax extenders bill package that's also been pending. They're trying to sort out and look at tax extenders that have expired throughout the years, if they need to bring those back, if it's really important to revive those as we have sort of consistently on a year-to-year basis, or if some of those can die. So that's been a really big policy debate that's been pending, and our disaster relief bill is unfortunately sort of paired with that right now. So we're watching that as well. So as soon as we get anything in the works, we'll be sure to put that on our website to let you know about that as well. So another thing that was interesting that happened this week was the Iowa governor did sign the Iowa Hemp Act. So Iowa is like a number of other states that have responded to the 2018 Farm Bill. If you remember, the Farm Bill did legalize industrial hemp. What that means is that it was removed from the list of Schedule I offenses. So it's no longer a drug offense to grow or possess industrial hemp. What it doesn't mean, though, is that it's legal to produce it. And so even though we have a new law federally that means that you can possess industrial hemp and it's not a Schedule I drug offense, and now we have the Iowa Hemp Act, which allowed Iowa to also take it off of the list of controlled substances in Iowa as well, we're not yet at the point where it's actually legal to grow hemp. And that's because both laws, the federal law and the state law, require growers to wait for regulations to go into place, because these laws envision a system under which the industry is still going to be heavily regulated, because the definition of industrial hemp only applies if the THC level is 0.3% or less. And so part of it is going to be that there's going to have to be a system of checking to make sure that whatever's growing out there in the field really is industrial hemp. It really has a THC level of 0.3% or less, and that it's not more than that. So that's something that has to get into place. So what the Iowa law does is it authorizes the Iowa Department of Agricultural and Land Stewardship to create rules and regulations to create a system to create a system in Iowa where Iowa growers can start growing hemp. The legislature has restricted that to 40 acres. So an Iowa grower, once the regulations are in place, will be able to grow 40 acres or less, not more than that. And there will be a number of other regulations that will go into effect too, that will govern inspections. What happens if they determine that you're actually not growing hemp, you're growing marijuana? Well, then there's a procedure whereby all of the crop will be destroyed. So just a number of things have to happen. So Iowa will create its plan. It will submit that plan to the USDA. The federal government, once it gets its regulations in place, will check over the state plans and either approve them or deny them. But if the state plan is approved, then it looks like for the 2020 growing season, the state and federal government are both on board to try to get those regulations in place. So growers maybe start growing this industrial hemp for 2020. But again, one of the things that they have to look for is there really a market for it? They may be able to grow 40 acres of it, but what are they going to do with it? So there's just a lot of questions and a lot of interesting things I think that we need to think about when we look at this. But at least step one, we have a law.
Yeah, it sounds like there's lots of things that are going on state and federally that we'll have to keep our eyes on.
So one thing that Kit's been taking a look at over the last couple of weeks are the right to farm laws around the country. And that's been a really interesting project. And she's put together a really nice list of all of the right to farm laws around the country, a list of the different states that have them, which is all 50 states, right, Kit?
Right.
Yeah. And so she's put links in there where you can actually go and read all of the different right to farm statutes that are out there. And she's also summarized some of the key developments in this law in terms of different state statutes that have been challenged over the last couple of years. So it's a really interesting resource, and I think she's going to talk to you a little bit about it. One of the interests in doing this came up because didn't we just have a case that came out of the state of Indiana that upheld its right to farm statute?
Yeah, that's right.
Oh.
Yeah, there has been some recent cases going on regarding the right to farm, especially in Indiana. So as many people know, right to farm laws have been enacted in all 50 states, and kind of in a way to address the concern of urban sprawl and the effect urban sprawl would have on farms as urban residents moved next to a farm and then complained and brought nuisance lawsuits against these farms for the naturally occurring sights, odors, sounds, and things just that naturally come with farming. So while these right to farm laws do vary from state to state, in general, they deny nuisance lawsuits against farms that first follow all the applicable laws, and second, that they predate the plaintiff neighbors. So Indiana just had one of its most recent controversies regarding the right to farm. On April 22nd, 2019, so just last month, the Indiana Court of Appeals found that its right to farm law denied nuisance allegations brought against a farmer and his two sons. So the plaintiffs in this case were the neighbors, and they brought claims of nuisance, trespass, and negligence, as well as different state and federal claims. In this case, which is Himsel versus Himsel, the farmer decided to make a switch from growing crops to raising hogs. And he, in 2013, built two 4,000 hog production buildings. In that case, the court really looked at the history of the land, who was there first, and whether the farmer was negligent in his operation. So the court found that this area was agricultural, that the nearest neighborhood was over 2 miles away and the closest town was about 5 miles away. Looking at that, in addition to the fact that the farm had been used, or the land had been used as a farm since the early 1940s, the court found that These were all vital factors in determining whether the right to farm could apply. So even though the plaintiffs had been living there longer than the farmer, since the land had been used as a farm for so long, it really protected these farmers against the nuisance lawsuits. The farmer was not operating his farm negligently, and in essence, it seems like because the plaintiffs came to the nuisance, they were unable to bring their nuisance claim. And interestingly, the Indiana statute regarding right to farm law actually has a provision about a significant change in operation. So despite the farmer changing from growing crops to raising hogs, the Indiana legislator or the Indiana law specifically states that converting from one type of agricultural operation to another is not a significant change. So in that case, the court not only upheld the constitutionality of the right to farm laws, but it also said that the right to farm applied in this situation and that it barred the nuisance claims.
So it's interesting, isn't it, Kit, that the court in Indiana said it was constitutional to bar damages, even in a case where I move next door to someone who's a row crop farmer, and then suddenly they start producing livestock, which is a totally different operation. And the Indiana court looked at that and said, nope, that's still constitutional, right?
Yeah, and it seems like maybe this issue has come up before because just in 2005 is when Indiana amended its right to farm law to include that.
It just shows, right, that different courts in different states come up with different results. Because we've looked quite a bit at our Iowa statute and the long drawn out history that we've had in Iowa, right?
Right.
Most recently, we had a Hahn-Michael case, which sort of looked at it. But those of you familiar with the Iowa statute know it goes way back. And in 1998, we had the first case in Iowa where the Iowa Supreme Court declared our statute at that time, our right to farm statute, to be just completely unconstitutional. What they said is by barring damages to a plaintiff who said that their land had declined in value, the state was imposing an easement on the plaintiff without compensation. And so it was an unconstitutional taking. And so, you know, in light of the facts of that case, our legislature had passed a new statute in 1995. They passed that statute while the whole Borman matter was going on and before the actual Supreme Court decision. But the new statute was challenged in another key case called Gackey, right? Where that case actually launched our current interpretation of the law, where in Gackey, the court went ahead and continued to say that it's unconstitutional to deny a plaintiff takings damages for diminution in value. But then they did this thing that's really confused district courts ever since. And that is, they said, okay, but for special damages, we're gonna kind of apply this three-part test to see whether or not it's constitutional to deny those damages. And we're not going to get into all of the details about Gackey, except just to know that the Iowa Supreme Court is the only court in the country that has ever declared a right to farm statute to be unconstitutional. So it's been a long haul in Iowa. We've had a number of district court cases since the Gackey case. Just a case would come in, the defendant would say the right to farm statute protects me, and the district court would say, nope, unconstitutional as applied to the plaintiff, see Gackey, and they wouldn't do any sort of fact finding or anything else. So finally, last summer in the Hahn-Michael case, we finally got this issue up before the Iowa Supreme Court to say, okay, what is the standard now? And basically, Hahn-Michael just affirmed Gackey, but said, but district courts, we really meant it when we said that there's a three-part test. And we really meant it that you have to actually go through those factors that we told you about in Gackey to determine whether or not all of this interference was unreasonable. and that basically there's going to have to be an evidentiary hearing. And so in Iowa, things have gotten really complicated. And even though we have this right to farm statute, if we're at the point where we still have to do fact finding, we still have to do discovery,
That's going to add up.
yeah,
That's going to
right.
be very costly.
We still have to have the evidentiary hearing. It sort of still remains to be seen. We have a number of cases that are still pending. So there's a lot going on in Iowa, but it's just an example of how one state has gone in a really totally different direction than our sister state over in Indiana that you were talking about.
It's very surprising to hear how Iowa is the only state that has declared its right to farm law unconstitutional. But yeah, Iowa's definitely had its fair of challenges with that law. So in other states, not only has the constitutionality of the law been challenged, but sometimes it doesn't even apply. So as many of you know, North Carolina has had its ag nuisance lawsuits that resulted in incredibly high damages. It was just back in 2018 where 26 federal nuisance lawsuits were brought against Murphy Brown, which is a subsidiary of Smithfield Foods. At the onset of all those cases, Murphy Brown claimed that the nuisance lawsuits were barred because of North Carolina's right to farm statute. The federal judge in that case said, no, they did not apply. And that was because the plaintiff residences, and he believed, predated the defendant's hog farm. So the statute only applied when the environment outside the farm operation changed, not when the farm changed and created the nuisance. So because of that, there has been several cases that have gone to trial, resulting in very high jury awards. The first case, the jury awarded $50.75 million, and the second, $25 million. And then the third case, there was almost $475 million awarded to the plaintiffs. Now, North Carolina law does cap damages, so that's not how much they actually received, but this really shows you how limited the right to farm law can really be if it doesn't even apply and they didn't even get to use it. In response to that, the North Carolina right to farm law was amended. There was two main changes to the North Carolina right to farm law. The first one was that the claim had to be brought within 1 year of the farm's establishment or operational change. And the second change was that the law prohibited any person from bringing a nuisance lawsuit against a farm unless that person is the legal possessor of the property, and they had to live within a half a mile of the farm.
And there's just really a lot of unknowns, isn't there, Kit, when it comes to this litigation? So, no doubt the North Carolina courts will have a chance, most likely, to look at the new statute that North Carolina legislatures passed also to see if they think that that suffers from any constitutional infirmities. So, it's just it's a challenging area. It seems like the North Carolina lawsuits also caused a number of state legislators around the country to sort of get concerned about the protection that's available to their farmers. So we have seen a number of amendments this year in particular, haven't we?
Right, yeah. Our neighbors, Nebraska, their legislator voted to amend their right to farm law this past session. The main change to that law would be limiting the amount of time to 2 years that a plaintiff can bring a nuisance lawsuit against a farm. Nebraska has voted to amend their law, as well as North Carolina, like we said, Georgia, Oklahoma, West Virginia. There's been several states and
a lot of activity.
Yeah.
And our legislature in 2017 amended or created a new law, right, to cap damages. And so that still hasn't been tested in court because that law was not in effect when the Hahn-Michael case came out. So we do have a law in Iowa that restricts the amount of special damages that a plaintiff in a nuisance case can collect, even if they prove that there was a nuisance. They can get the diminution in value claims, they can get those damages, they can get any medical claims if they can if they can prove them, but they can only collect 1.5% of the actual compensatory damages as special damages. So that's something our legislature in Iowa tried to do to alleviate fear that our producers might get hit with millions and millions of dollars of special damages in these nuisance cases. So again, that's a statute that hasn't been challenged.
Right. There's been a couple states that have even amended their constitution to add in the right to farm law as a constitutional right. So that's been North Dakota and Missouri have done that. And there hasn't been significant challenges to those laws since they passed. Oklahoma tried to put a right to farm in their constitution, but that did not pass. So
I mean, Missouri is one of those states that actually upheld the constitutionality of its right to farm statute at the Supreme Court level. So the Missouri Supreme Court, was it 2015, analyzed its right to farm statute. And unlike Iowa, the Missouri Supreme Court said it was constitutional to prevent nuisance lawsuits against farmers. So a lot of activity. Big question, huge public policy issues. And thanks, Kit, for putting together such a great resource. We will have her resource out there on the website for those of you who want to go look at it. So I think that concludes our podcast for today. And thanks for tuning in, and we'll be in touch soon.
Thanks, everyone.